We're good.
So, Scott, I've gotten a little automated voice, so sounds like we're recording, right?
Yes, sir.
All right. So before we started the recording, we had a discussion that can really be summed up in taking care of a special needs child on a budget. So my name is Zale. I'm an attorney. I have multiple licenses. I have law, life, and health, as well as securities and investments. And what I enjoy doing is I enjoy helping people plan, but I'm a bit unique in that I'm not always looking for the high net worth clients. I typically help people who see themselves as ordinary. I typically help them make extraordinary plans. And so I use all the tools in the toolbox. And Scott and I were even talking about that earlier. We really like just the option of tools. We don't always know everything about all the little tools. And so we're constantly learning those, right, Scott?
Absolutely.
But we really want to bring all that to the table. And so the first thing that I want to discuss in this area is whether or not you need a special needs trust. So Scott and I all the time deal with folks that just have this idea that they have to have a special needs trust, and it's just not always the case. First of all, trust are about who or what you don't trust. So if we've got a situation where we have a child that has some special needs, and I'm very well attuned to a lot of that. I've been doing years worth of child welfare work, and for what it's worth, I'm also autistic with ADHD. So that may explain the information just coming out as a deluge. But do we need the special needs trust? A lot of times, especially in the autistic world, that autistic person can handle finances better than your neurotypical person. A lot of times they'll get into the details and know all the granular parts of it. And so, don't assume because somebody has some sort of diagnosis that they even need one, because they may not. Now, if we've got somebody who is on government benefits, absolutely. And so that's whenever we want to look to have a third-party special needs trust in place. They do not have to cost thousands. We're talking about doing this on a budget. All the time, I'll have people call into the office, and fortunately, they want to hire me because of Google rankings or whatever, or maybe I'm down the street. But they don't think about looking at whether or not they have workplace legal plans. Scott, you had mentioned one earlier. That was what, Legal Shield?
Legal Shield, yeah.
Yeah. So you've got Legal Shield. Also, as people have these benefits and they don't even think about them. Okay. And so Scott and I, both coming from the insurance world and the legal world and that sort of thing, look at your benefits. The major players in that are MetLife, ROG, Legal Ease, Legal Shield, Workplace Options. And so those plans, they offer everything from the fact that the plan will pay for the estate planning to it giving you a discount. But either way, it's a break, because a lot of people, one of the things that Scott and I have discussed before, a lot of people just have this fear of how much an attorney is going to run. And some attorneys, they set their office up so that you pay for all their advertising, you pay for the pretty brass and glass, and that shows up. And then there's others of us that don't necessarily have the prettiest office, because we're trying to make this affordable for everybody. So it may just be a matter of shopping around. It may just be a matter of looking at what you have available at your workplace. There are other options. There are do-it-yourself options. There are financial planners who think that they can do that they're not licensed to do that. If you have somebody who's not an attorney who's offering to do estate planning, ask them if they make a mistake, who's paying for it. Because if they don't have the license and if they don't have the errors and omissions coverage, nobody's paying for it. If they don't put their name on the documents, be wary. I've seen plenty of that where it has come in from the financial planner, but nobody's name's on the document because nobody's taking credit and nobody's taking liability, right? Yeah. And so, it is important, I think, to have an attorney do these, because we pay attention to the statutes, we pay attention to the cases. You have to look at both. Actually, and here's the drinking from a fire hydrant part. Actually, there was a case that came out recently that said the order of people signing the will mattered. in which case in that will, they had a witness to sign first, then they had the person making the will, then they had the second witness to sign, and the court said that wasn't valid because of the order of signing. And so it matters to have an attorney do it. Now, some of the self-help document prep companies have gotten really good. Okay. I've seen some of those that have come out better than even one of the attorney drafted packages that I've seen before. So I don't entirely discount that. Just understand self-help is what it is. You know, if you're comfortable to work on your car, feel free.
It's
You
an
know,
option, right?
right.
It's one of the tools that's in that toolbox that you just mentioned earlier. It's an option. And so, you know, there's risk with everything that you do.
Exactly.
There's a chance that it won't be the right thing with everything. Every choice you make has that possibility of it being incorrect.
Right. Exactly. But back on this topic of special needs trust, just don't assume that because you have a special needs child that you need a special needs trust. What's a situation that you don't trust? Is it them? Is it others around them that may be caregivers? That's fine. Are there state benefits that are coming in that could affect? Are they means tested benefits like disability and that sort of thing? That's a huge thing of really where you need the special needs trust. So don't just think because you have that child that you need it. Now, the second one that we had discussed earlier that's a big topic is a guardianship, or it may be termed a conservatorship. So one myth I want to dispel: if you're the parent of a child who's under the age of 18, you don't need a guardianship, just in general. I've had people to come to me for that, and because doctors have told them or whatever, and I don't understand the logic. There's nothing in the law that says if you're the biological parent, you have all your legal rights, all that sort of thing, that you also need a conservatorship. Now, if there's a situation to where money is coming in, I had this recently where a child had inherited money from a parent. There wasn't a trust or anything like that in place, that they needed a financial guardianship for the purposes of that money itself. That happens. But just in general, you don't. It's when the child's turning 18 and may or may not have issues. So in that situation, whenever people come to ask me, the first thing I ask is, can the child make decisions? Are they driving? Are they working? Because in those situations, you're generally better off with just having a financial and a healthcare power of attorney for the child so that you can assist the child, but you're not taking the power away. Now, if you have a child who truly can't do any of that, then that's where we, at about 17 and a half, we start teeing up the conservatorship petition, getting everything together. Generally we would file that the day after their 18th birthday so that, nobody has to do math because that can get weird sometimes. So just file it the day after, make it easy.
Right.
And then, you'll set it on the docket. A judge is going to have to look over that. And especially, depending on how special needs the child is, you're going to bring them to court, and so when in dealing with the special needs world, sometimes people struggle when, this whole idea, if you can't see it, you must not be it. That really affects especially the autism crowd, the ADHD crowd and all that. But, when the court can easily see it, when both parents are petitioners, those are no-brainers. So it really shouldn't be all that expensive. Now, understand, when you get a conservatorship, the court is involved for the rest of that person's life, for the rest of that conservatorship. So understand, you're going to be making annual reports. It's not just something where you get the conservatorship, oh great, the judge signed the order, and then you forget about it. Because you can get yourself into a lot of trouble when you just ignore the request from the court to do the report. So just understand, you're going to make an annual report. You may have to come in, especially if big chunks of money come in, you may have to go into court and deal with those. So, people often, they think, well, I get a conservatorship and then I just don't think about it anymore. No, it's like changing the oil in your car. I mean, you got to maintain it. But even that, now, does that require an attorney? Yes, I would not try that without an attorney. Can you try it on your own? Yes. You're really going to annoy the court. You're going to annoy the clerks doing that because there is some intricacy to that. So, that's really just kind of my thoughts on doing this on a budget. Scott, did I prompt any questions?
Yeah, I've got a couple of them that I think would come from some parents out there, and I'm trying to just kind of you mentioned government benefits, and I think that would be probably, if I were to generalize it, Everybody is worried about losing SSI or
Yes.
SSDI, really is
Yes.
what it ends up being, right?
Right.
And then they're also worried about when something happens to them, you know, what the stuff we hear out there with rumors is the government takes our house and takes our assets and takes all of our money. And so, you know, and you mentioned, you know, some folks, you know, from a special needs, like on the spectrum of all, and I don't mean autistic spectrum, I just mean the
Right.
spectrum of all the different needs that are out there and circumstances. Some of them are going to go the direction of government benefits, and some of them are going to work and you know, earn income and whatever else. But
Right.
I'm speaking more towards the government benefit side now. What
Right.
are some pitfalls there? What are mistakes that we can make as parents? What should we avoid, or what should we absolutely do to make sure that 10 years from now they're not taking somebody's house? I guess is the way I would word that question.
Okay, so let's split those real quick.
Okay.
So typically, when you see the house taken, typically we're talking about Medicaid long-term care. Okay, so we're talking about people in nursing homes. So we're on the other side of the spectrum of life. So let's take that one out for a minute. When we're talking about means tested benefits, you know, and I don't profess to be a disability expert, so understand that. But when we're talking about any general means tested benefits, if it's something that they have qualified for, what you don't want is you don't want them having receipt or even constructive receipt of large chunks of money, large chunks of property, that sort of thing. And so that's why we want to see that go into that third party special needs trust where somebody else controls them getting the money. They don't have the right to demand payments, that those assets are to support but not supplant. That's the magic words. Often in law, we have magic words. That's the magic words. Third party special needs trust, support, not supplant benefits. And so that's what we're looking at there for those. Now, let's talk about the whole taking the house. Medicaid has two mandates to collect from people with assets. They have federal and state, okay? And so when we're looking at somebody at old age, when we're looking at them applying for Medicaid, and especially people get Medicaid and Medicare confused. Medicare, you've paid in, they don't get to collect for that. Medicaid, you have not. It is old age typically, and what we're talking about is long-term care benefits. And so on that, whenever it comes to qualifying for the Medicaid benefits for the long-term care, for generally a nursing home, you know, they're going to look at what assets you have, what are exempt for the purposes of application, like a house under 700,000 and a car and that sort of thing. What's not exempt, like chunks of money that you have access to. Okay, that's where we talk about the spend down. But where they go after the property is, you know, once, you know, let's say that we've got two spouses, one's going to nursing home, one's not. The house is excluded, but whenever that second spouse passes away, they have a claim against the asset, against the house. They don't push anybody out. They don't actively go after it. Matter of fact, in probate, we have to send Medicaid a request for release to even get them to you know, go through and look. I mean, you know, so they don't go to running to the Register of Deeds office to make a lien or anything like that. They just wait because they're the government, and they know that house can't be sold, whether with probate or without that release. And so that's where that comes from. Now, just a real quick side note on that, that's where we hear about what's called Medicaid Asset Protection Trust, which is a trust typically for older people. It's an irrevocable trust where we're putting that asset, typically the house, which is what I tell people all the time. It's not something that you want to sell off and move to Florida. You're not looking to put a home equity line of credit on it, anything like that. Typically, it's an outright owned house that they want to pass to the kids, and they don't mind going to the government and asking them where they're going to sleep and who the roommate's going to be, because that's the way that works. You have to go to a place that has a Medicaid bed. It's going to be a semi-private room, and you don't have any control over that. And so if that's what you want, understand. Now, you could talk to somebody like Scott about long-term care coverage, and there's many ways to do long-term care coverage. It's not just use it or lose it anymore. And you know, prepare for that. But really that Medicaid issue is really for people who just haven't made any plans, don't really have a lot of money, all that sort of thing. Did that make sense?
It makes perfect sense. Yes, absolutely. Um, Talk to me about or talk to us since we're recording this.
Yeah.
What if we do nothing? And so, and where I'd like to ask you to speak a little bit toward specifically in Tennessee, because I know
Yes.
that and you always talk about how every state is different, and you got
Yes.
if you're listening outside of the state of Tennessee to this, then obviously, some of this may not apply. But there are some things specific to life insurance. There are some things specific to fraternal organizations. But if I'm a parent and I just get overwhelmed with taking care of my child, and I keep, I have my long list of or my stack of things to do, and my planning ends up it's always tomorrow, it's always tomorrow, it's always
Right.
tomorrow, and I never get to it, and then something bad happens to me. What's that going to look like? What if I
Sure.
just do nothing? I don't have a trust. I don't have a will, a power of attorney, but I'm a 51-year-old guy today, and I keep putting it off, and I'm in an accident tomorrow, and my son, who is severely disabled and cannot take care of himself. What's going to happen? What does that look like for where is he going to go? What's going to happen to my life insurance? What's going to happen to my 401, my IRA, those things. And feel free to go as deep or as not deep as you want, but just what does that look like if I do nothing would be the question.
Right. All right. So I'm going to give you a job is make sure I answer all of that question.
Okay.
Because there's 1,000 different directions that I want to run all the time. Okay. All right. So
we only have an hour left, so we have to hurry up. So.
Sure. All right. So disclaimer, I'm a licensed Tennessee attorney. I'm not trying to transact business in any other state, and just listening to this does not make you my client. I also have licenses for life and health that are Tennessee and other states. I have a securities license that is primarily Tennessee, but I can reach into others on a limited basis. So that's my disclaimer, and none of you as of today are clients, including Scott. All right. So everybody, I get this all the time. People read on the Google these horror stories about probate not having a will and all of that. Most of those stories apply either to states like California, Illinois, New York, even to some degree Kentucky, because of the way their probate system is set up, the way that it is designed to cost unnecessary amounts of money. Okay. Tennessee is not that way. At its heart, the intestate statute in Tennessee is not bad. Matter of fact, sometimes it is easier to go under the intestate statute than some of the stupid things that people write into handwritten wills. Okay. Sometimes Tennessee does allow handwritten wills. Understand that has to go through probate to be effective. And if you handwrite a will, you have to have two people who can recognize your handwriting. 30, 40 years ago, that wasn't a bad deal. Now, with texting, email, all that sort of thing, who in the world can recognize your handwriting? Okay. So in theory, it's cheaper to go to an attorney, have a properly drafted will, trust, whatever. I'll touch back on that in a minute. As opposed to the holographic or handwritten will, because they can be more expensive than the planning once you have to prove it to a court. So the point of that conversation is for purposes of Tennessee, the intestate statute is not bad. I've got clients who I've done retirement planning with that I've looked at their situation and it just doesn't bother me. They're a nuclear family, no divorce or anything like that, no stepkids or anything like that. Their kids are fully functional adults, no trust issues there. That going intestate just doesn't bother me because it's just not that bad. Now, the problem that can be created is people. So if you've got a person that could come in and make a stink, intestate could be problematic. Now, wills versus trust. My head explodes. I'm getting better, but my head still explodes every time I see the ad, wherever it is, it says will or trust. That thought shouldn't exist. You always, if you're doing estate planning, want a will. And I'm going to touch on that in a minute, but a trust is optional. Again, I said earlier, trusts are all about who or what you don't trust. So a trust is optional. Now, California,
Stop real
Illinois.
quick if you don't mind.
Yeah.
Who would I not trust? Tell some parents, like, you
Your
know,
kid,
who do I not trust?
your ex-wife,
Mhm.
your kid's wife. You know, some people just have a distrust of courts, judges, the probate system as a whole. And so we do trust to try to make sure and avoid that. So, but maybe it's a government. If we've got somebody with government benefits, like we talked about earlier, then you don't want that kid getting a chunk of change because it could disrupt that. But and it also varies on, you know, what your level of need of control is. I mean, if you're just an utter control freak, you need to have a will, you need to have a trust, and you just need to schedule with your attorney that you're going to meet and touch it up once a year. Okay. Now, I want to, one of the things that you asked about earlier were how things flow with benefits. And so people and even attorneys seem to have a misunderstanding of this. And my understanding of this grew as I added those other licenses. Okay. So I talk with people all the time. So here's my standard spiel. The way things pass when you go on to your reward is we look at beneficiary forms first. Those control that account. A beneficiary form is a form of a trust wrapped in a contract. It's very efficient. It's very cheap, but the problem is people often ignore them. Okay. So wills, trust, that sort of thing really can't reach into those and change them. Okay. Attorneys seem to think that they can, but that is a trust wrapped in a contract. So an outside document, there's no structure for a will just reaching in and changing it. All you're doing is creating problems. Okay. So we look at beneficiary forms. Then we look at way things are owned. So typically husband and wife, typically you're going to own your house, you know, as husband and wife, which in Tennessee is joint right of survivorship. First one passes away. We don't need to do anything. You know, I have people all the time says, well, you know, my spouse passed away. I want to clean up the deed. I used to do that. Now I just challenge them. Why? Because all you have to do is show up with a death certificate. Is somebody arguing that they're not dead? So beneficiary forms, joint ownership. Now, if you choose, if you're a fully functional adult that wants to plan, doesn't mind spending a little money for it, if you choose to have a trust in place, then we look at trust. But understand trust control, what you put in them really well, they struggle with everything else. And so what I'll see all the time is I'll see these nice trust plans that are drawn up, whether they're self-help or the different legal groups Scott and I have talked about before, whatever. You know, they'll typically bring them in a nice box that doesn't fit in anything. You know, I like things to be able to fit in the firebox, fit in the file cabinet, whatever. These boxes don't fit in anything. It just perplexes me. But there won't be anything in the trust. They didn't deed the house in the trust. You know, they haven't directed any beneficiary forms to the trust, all that sort of thing. It's just a dry trust. So trust handle what you put in them really well. They struggle with everything else. So beneficiary forms, joint ownership, trust. Now we get to the will, because the will catches everything that wasn't caught by something else. Okay. And then if we don't have anything in place, then we've got the intestate statute. And in Tennessee, it's not bad. Yeah, I hear it all the time. I don't want everything going to the government. Well, rarely does anything go to the government, because they try very, very hard to find a family member for that to go to. That's called escheating to the estate or to the state. I've never seen a single asset do that. Not saying it hasn't. I've just never seen it happen. So that's really not a concern. So long as you've got family members, it's got a place to go. Now, sometimes it may be hard. You know, I've got clients that, you know, don't have any kids. You know, families died off. I mean, we'd have to do an air search, really to be able to find anybody to give something to. And that's tricky for the court, because, you know, the court doesn't want somebody showing up, you know, a year later and saying, hey, you know, y'all missed me. So, you know, that's really the way things pass. So what I recommend everybody do is, first of all, look at your beneficiary forms. Make sure they say what you want them to say. Don't get cute. Don't say, well, you know, I want this person to take care of my child. I'm not going to put any other documents in place, but I'm going to give all my money to them. Well, if you want to give all your money to them, that's fine. But if you're giving it to them for the benefit of the child, you need to put some documents in place. Because, you know, I've had the situation before where, you know, after we got done with the planning, the lady went out, she changed her life insurance beneficiary form to her executor. We don't know why, but the executor got her house paid off. Was that what she wanted? I have no idea. But that's what happened. Her kids didn't get the money. The estate didn't get the money. The executor did. So make sure beneficiary forms say what you want. Now, if you want, money controlled for special needs purposes and that sort of thing, typically, if you're married, then that means a trust is going to be the contingent beneficiary. If you're single, then it may be the primary beneficiary. But, typically that's the way that works best. We really don't want trust owning accounts that can make a lot of money. We want the trust to be the beneficiary, and understand, if a trust makes money, makes too much money, get taxed pretty heavily, but that's kind of the trade-off, right? It may be the trade-off of, yeah, Uncle Sam's going to get a big bite of it, but we still need this money controlled for the child. And that's an individual decision everyone has to make. So
Excellent.
what questions did I create?
Well, let's talk about the tax part for a minute there. If a bunch of things start going into that special needs trust, so a house under 700,000, I think I heard you say, or just any house, I guess it doesn't matter. But as that dollar amount goes up, is there a way to take money out of it? Can somebody, could the trustee, or maybe it's the family member that's controlling that, whatever it is, are they able to say, well, we're about to go over some threshold, let's move some money out? Can they buy another product? Can they spend it? What would be some options to keep the tax money down?
If they're given the power to do it, absolutely. And so understand, the issue is not receiving assets. The issue is assets that are making money. So that's why you'll hear all the time in the financial world, we don't want trust owning, market accounts and that sort of thing, because they can get taxed really, really hard. But we don't necessarily mind a trust receiving a house. That's because it's, unless it's a rental property, right? It's not really making any money. I mean, the asset's growing. You may have to deal with capital gains at some point, but it's not making a lot of money. It's when we have assets that are making money that we want the trust, I think at least, we want the trust to be as flexible as possible. Now, you've got to strike a balancing act. If you've got a third-party special needs trust, it's just supposed to support but not supplant, right?
Yep.
You got to have a bit of a balancing act. So that's why I believe if, whether or not you have a professional trustee involved, or if it in bigger trusts, really, if we're talking millions of dollars, you seriously need to consider a professional trustee. But if we're talking about an individual that's the trustee, then they just need to seek out counsel with a CPA.
Now that brings up another question, and that's a good, just a quick conversation. What are these? Let me give you my perspective, and then you can maybe add or subtract. I look at if with my son, when I'm gone, I want him, like, he's going to have, if all else fails and there's no family for him to go to, or my kids might change their mind. They tell me now when they're 11 and 12 years old that they want to take care of my son forever. That might change. I don't know.
Right.
So if he's living by himself, and maybe he's even in a state run facility of some sort, or here in Middle Tennessee, it's there's some group homes where he could live with a couple other individuals or whatever. So maybe he's in some environment like that. His standard of living is going to be different, maybe, most likely, than mine or the parent of this child, right? And so I want my son to be able to go to a water park or go have fun and do these different things.
Right.
But the state is not going to be packing up the van or the bus and taking 10 people over to the water park 3 times a week to have fun and whatever else, right? They're just basically living in a house or living in a facility, and meals and the daily stuff, right? So my interpretation of that is, if I want Ridley, my son, to have a better, or what I would describe as better, not everybody describes what I describe as better, but just a different lifestyle, I'm going to want to tap into that special needs trust and use the money to be able to go get fancy clothes, a haircut, the water park,
exactly,
go see a movie, go to a show, go on a vacation with my sister. I don't know what it is, right? And would that be some good use of special needs trust money? And then what else is a good use for that? Because that's just my limited understanding of it.
So I get this actually from folks who do the special needs trust work, because we've got a group here. It's in Mount Juliet that is a special needs trust administrator.
Mhm.
And so, they get creative all the time. There's all sorts of things like the water park that you might be amazed about that they will spend money on. And what you're dealing with is you're dealing with the emotional well-being of the person. Sitting around in that boring group home does not bode well on emotional health.
Right.
So whenever they can go take the trip, or whenever they need a new iPad or new laptop or whatever it is, there's where that supporting comes in.
Love it. Love it. The another question I get a lot is, I don't have enough money right now to hire somebody to put together a trust, but I've got life insurance or I've got other assets that when I die, I'd like them to use the money then. So the example that I would give you is, can I structure something in a way that right now, while I'm still alive, I can use my cash flow for my family, for my whatever. And then, but when I die, I've got that $50,000 or $100,000 life insurance policy.
Right.
Can I write it so that I die, you cash the check for the life insurance, you pay the attorney for the trust, and everything that's left over goes in?
No.
Okay.
I don't know of any way to do that. I mean, but honestly, if they've got the assets that you described, they've got the money to hire an attorney to do it.
Agreed.
They just don't want to.
Yeah.
I mean, let's just be honest. If you've got the money, whether it's and even if it's a situation to where, okay, well, my life insurance is based on my employer that I want to be able to use. Well, you got a job. Okay. Whether it's looking at your benefits and seeing whether or not you have prepaid legal, or whether it's setting a little money aside, whether it's shopping around and finding an attorney that's going to do it reasonably, you got the money. You just don't want to. Right. But there is no good way that I know of to well, there's one, but it would actually be more expensive. So if they sat down and if they did a trust and did a will, and in their will they put a trust called a testamentary trust, and they directed the life insurance proceeds to their estate, that could happen. The problem is it's like anything else. Is it cheaper to change your oil when you're supposed to, or is it cheaper to buy a new engine? So it's the same thing. I'll see these. I've got one now where they did a testamentary trust, which was a paragraph. So we have very little instruction as to what they intended, because that testamentary trust is a paragraph. We've got to go through a court, a judge. We need the blessing of a judge for that. So it forces probate and that sort of thing. And so that's replacing the engine. So yeah, if they wanted to do that with a testamentary trust, they could. They're just going to spend more money ultimately.
Gotcha. I mean, the language I use is good money and bad money. Good money is getting your oil changed and
Yes.
paying $100 at the express place or whatever for the synthetic or the best oil you can put in there, or even doing the transmission fluid change. I don't need that. It's $99 and it takes 45 minutes. I don't need that.
Right.
Well, the alternative is the $4,000 transmission in 6 months, right? Or 2 years, whatever that ends up being. And so those are the choices we have. Back to choices. We all have choices we can make. Last question I have is, maybe another scenario. And this is where there's a heart for, I look at this as a heart for orphans and widows, right? And
Sure.
Widows biblically are also single moms, divorced moms are widows, right?
Right.
And so at the end of the day, 86% divorce rate. Last I checked, somebody will call me out. It's 82. Oh, it's 94, whatever.
Right.
Close enough. 86% divorce rate in the special needs world that we live in.
Okay.
So there's a lot of single moms out there that are raising kids, and let's just be honest, a lot of those dads are gone. A lot of those
Yep.
dads are court ordered to pay child support, but they're not,
Right.
and whatever else. What do you recommend a single mom do? How she doesn't have the hundreds or the thousands of dollars to pay an attorney. Maybe can't even do the monthly for the different legal services that we talked about. What would you recommend if you were sitting across
So,
a single mom right now? What would you tell her?
right. So the biggest concern there is not about managing money because they don't have any. The concern is who's going to be the guardian for the child, right? And so that is best done, as far as I'm concerned, only done in a will, because you can't will away your children, but you're nominating a guardian. And you could even do that. That's one of those areas where, that handwritten holographic will may not be such a bad idea. Okay. But typically in that scenario, you're going to name a primary and you're going to name an alternate. What you are not going to do is put an or, because here's the problem, because I'm dealing with it right now, is in my situation, the or is not in the children's lives. And yet I still have to get the or served because somebody put in their will, this person or that person.
Ah,
Okay. So you name a primary and then you name a backup. And if you want to do husband and wife, so an and or in that situation, that's fine. But you make it very clear. Here's my first choice. And then here's my second choice. So that's the biggest issue there. And in that situation to where the father is out of the picture, it's especially important, because let's say that you've got a mother that's primary residential parent. Maybe the father's completely cut out. The court's in a lurch. They're in a really tough spot because they've got a parent who has parental rights, but doesn't have any parenting time rights because of an order, because of a parenting plan. Where do the kids go? So that's my biggest thing, is even if that person sits down and handwrites the will and nominates guardians in the will, that's an affordable way to do it because there's no other assets to really have to worry about.
love it.
Make sense?
Love it. It does. It does.
Yeah.
Last thing on my mind is outside of the legal world. So I'm going to ask you to shift gears into your life and health insurance
Yeah.
license and your financial,
Yeah.
your series licenses, right?
Right.
I a question that I get a lot is my son or my daughter has a disability, and because of that, they don't qualify for life insurance.
Okay.
And so, what do you suggest to people when that's the case?
So they have the disability, they don't qualify for, why are we buying them life insurance? Because
Okay.
in that situation, typically it's the parent that we want to have life insurance to be able to fund the child, right? And so that's where, even we see the unique policies, the survivorship policies. I just got done writing one of those where, the family had spent a lifetime of purpose work. They'd been missionaries and that sort of thing. So all of their time has been spent on purpose, which doesn't generate much revenue. Okay. Have a special needs child, and they wanted to be able to leave something for that special needs child. So on the law side of what I do, we did a trust. And then on the life and health side of what I do, we did a survivorship life insurance policy, where you take 2 lives and it's a second to die policy. So whenever the second one passes away, that money is designed to go to the trust and to fund the trust. That to me is where you see life insurance. Now there's a few other things, especially for that parent, if they want to, because you can overfund a life insurance policy and take advantage of the IRS rules that apply to it. So, a family may consider having a life insurance policy, overfunding it. And that way, so for example, whenever they've got this child that they're dealing with, that doesn't show up on the FAFSA form whenever they're applying for student aid. That wouldn't show up as far as applying for benefits because it's something that the parent has in that policy. And also, it's one of the few areas where somebody can stick assets, and especially for Tennessee, They can stick assets into it. They can have access to it, but their creditors can't attach to it, not even in bankruptcy. And that to me is just huge. And you get all these people who say, it's life insurance. Well, there's very vocal people out there that had they had their money in life insurance, in cash value life insurance, they could have used the Tennessee statute to keep it out of bankruptcy.
Yep.
And instead, every dime of what they had went through bankruptcy because they didn't know that and still preach against it.
Yep.
That help?
We live in a state that is very friendly with the way the laws are written in some scenarios, right? I mean, laws are laws, and every state has their flaws. But at the end of the day, we live in a state where the law is pretty friendly in this regard, and so we should take advantage of that if we can. And sometimes that's just a matter of knowing the law or talking to somebody like you that knows it. So, first of all, thanks for your time. You and I are both very direct, so I don't have a ton of things to close out with. Any last remarks, anything that you would, or a pitch for your phone number or your email address or something like that?
Well, I'm easy to find. I mean, it's ZaleDowlen.com, ZALEDOWLEN.com, and from the legal side of what I do, I do a fair amount of work as guardian ad litem and that sort of thing. And I get a kick out of these parents that says, well, I couldn't find you. Well, you type in Zale Dowlen in any search engine, I'm going to, other than the paid ads for Zale's jewelry, I'm going to be the first 3 pages. So I'm pretty easy to find when it comes to that. But, I would just say educate yourself. Understand that there's some information out there that appears to be good information. It's really just a sales pitch. Understand that, we're not California, Illinois, or New York. Understand that, especially, a lot of the folks, Scott, that you're going to be talking to are moving into Tennessee. They're moving into Tennessee for a reason. And so don't bring the information that you understood from that other state and simply assume that it applies here. The probate process, that doesn't apply here. We talked about the protections on life insurance and annuities. What I have seen as I have looked at all the various states on that is the redder, the better. So, it applies for different states. Understand, I'm near you and I both are near the Kentucky line. Understand when you move across a state line, things change.
Mm-hmm.
We got all sorts of people moving up to Franklin, Kentucky because the houses are cheaper. Yeah, they are. But they're still commuting in and out. Well, there's a cost factor to that, and don't assume all the laws are the same.
Right.
So that's pretty much it.
Yeah, and my final words on this time together would be, from a parent's perspective, is, and you already touched on it a little bit, don't believe everything you hear.
Right.
And sometimes talking to other parents about their experiences and the world that you and I live in, that referral based is, hey, here's somebody you can trust. Here's somebody that's done this before. You mentioned a sales pitch. A lot of times people are, they'll use fear to drive a sale.
Right.
And I don't like that. So let's give it to them straight. And instead of saying, well, if you don't hire an attorney, everything's going to fall apart. That's not always the case. It could, but it's not always the case. And so I've been trying to use a mantra of parent to parent, right? And so we can talk to each other, not that you don't ever want to involve professionals, but we can talk to each other and share that experience, talk to other people about it, but then go get professionals, right? I'm not saying you leave them out. I'm not saying that parents handle this on their own, but sometimes having that conversation, because looking at a billboard or looking at watching a commercial or hearing a radio ad or something like that is not always going to be somebody with the right heart to help, our families and our children. So I appreciate the fact that you are one of those, and I appreciate your time. And that's all I've got. So I'm going to hit the button. Stop.
Let me throw in one other thing, because it kind of sums up what you and I talk about regularly anyway. We want what works. Okay. So if it's a matter of that somebody's gonna just have a will that they're not going to touch for 40 years, okay. If it's very simple, right? Or if it's a matter of a beneficiary form and we've got money that we need to go to somebody, or we want to split up money, we want what works, not just what everybody tells us is going to work.
That's a great way to wrap it up and put a bow on it. Thanks, Zale.
Thanks, Scott.